So for the first lecture, I'd like to talk a little bit about the Constitution itself in the framework for government that it sets up. Obviously, there's a lot to the Constitution, and you'll spend your first year of law school studying it very thoroughly, those of you going to law school, and then move on. But pretty much, it fills up a lot of your time as the basis for the law. But it's also the basis for the system of government that we have, the federal system. And I just want to talk a little bit about ways in which the Constitution establishes our government and why our government is set up the way it is. So, first of all, it's designed to have each branch of government with various checks and balances on the others so that no branch of government is more powerful than any other branch. The legislative branch has checks and balances on the executive branch. For instance, the House can impeach presidents. The Senate sits in trial on presidents who've been impeached. If without an electoral majority, the House chooses the president and the Senate chooses the vice president. Congress can override a presidential veto with a 2/3 vote in both the House and the Senate. The Senate has a lot of authority over executive nominees who must be approved by the Senate. Only Congress can declare war. Only Congress can levy taxes. And also the Congress can ask the president for a State of the Union address or offering each year. So some of the legislative checks on the judiciary include the Senate's ability to approve or not justices of the Supreme Court. The House can impeach those justices. The Senate would try those justices. Congress can create amendments. Congress can create lower courts. In fact, Congress established the entire judicial system. Only the Supreme Court is mandated by the Constitution. And Congress can add or subtract members to the Supreme Court if it so chooses. In terms of the judicial branch's check and balances, the big judicial branch check on the legislative, something we'll be talking about in the future, and it's called judicial review, which gives the court the ultimate authority over what laws that Congress passes actually mean and how they should be applied. The judiciary has that same authority over the executive branch, and it also has the authority to sit in impeachment trials that occur as a result of impeachment. The Chief Justice of the Supreme Court would serve as president of the Senate in those cases. The executive branch has checks and balances of its own over Congress, including the power to veto. The vice president serves as president of the Senate, so he or she has tie-breaking abilities in the Senate. President serves as commander-in-chief of the Army. President can make appointments, recess appointments if the Congress is out of session. And the president has the authority to call Congress into session. And on the judicial branch, the president has the authority to appoint all those justices. And then the president has pardon power. So if he doesn't like the way the courts have ruled in a federal case, he has the authority to pardon people who have been convicted of federal crimes. So all of these checks and balances are designed to keep the three branches equal. It turns out that over time, we've actually had we've had peaks and valleys for the power of each. Today, and since World War II, the president is considered probably having the most power of any of these branches. But definitely Congress pushes back. I mean, look at today, even the Republicans own both the White House and the Congress, yet there's lots of congressional pushback against presidential authority, which is a little bit unprecedented. And could also argue that the Supreme Court wields a lot of power. It has the ability to alter marriage laws. States can no longer discriminate on the basis of sex, who gets to marry whom. That's a lot of authority. Similarly, during the 50s and 60s, during the Civil Rights era, the judicial branch wielded a lot of authority, really had a lot of impact over society, and some of the decisions it handed down, most notably like the Brown decision, Roe v. Wade, big decisions that really affected public life in America. That's the power of the judiciary. So up and down it goes, and each of these three branches sort of looks out for itself over historical time too. They always sort of put their own interests first, as you might expect, and as the founders definitely counted on, which is why they gave us all these checks and balances. So the next thing I want to talk a little bit about regarding the Constitution is the creation of a federal system versus what it was under the what the country was under the Articles of Confederation, which was a confederal system. This is just a pretty basic graphic showing you three types of national government. France, for instance, is a unitary system. So there's the national system, or the national government, and a creation of states, but those states don't really have any authority outside of the national government. So the national government is supreme, and the states are just basically administrative units within that government. They're not separate governments of their own. It's different in a federation because each of the states has its own government, and then there's also the national government. So this is what the Constitution creates, which is shared authorities, shared sovereignties. And as we'll see as we go forward, there's different powers. So there's powers that are reserved for the national government, there's powers that are reserved for the state governments, and then there's concurrent powers that both share. And that's the system. And in this system, the federal government in the Constitution is supreme over state governments, but not in all ways, in ways that are clearly enumerated within the Constitution. So we're, along with Canada, India, Germany, a lot of modern nations use the federal system. And then finally, as we were with the Articles of Confederation, in that case, the states have the supreme authority, and basically they control the national government. So the national government is just sort of this agreement between states on how certain things should be run. And as you know by now, the Constitutional Convention was called to fix the Articles of Confederation. So basically keep the same system in place where the states trump the national government, but just fix some of the problems with the articles. Instead, they created a completely different system in which states and state governments and national governments work together under the authority of the people. So I discussed a little bit these enumerated powers and reserved powers, the powers that are reserved for the states, and also then concurrent powers, which both types of government share. So you can see some of these listed here. The concurrent powers, obviously both state and federal government can collect taxes, they can both borrow money, they can both make and enforce their own laws, establish court systems, charter corporations. But the states are not allowed to coin their own money. They can't regulate interstate commerce. They can't conduct foreign affairs. You can see the list there. And then the federal government can't interfere with the reserve powers of the states to regulate their own internal commerce, although we'll see that's really changed. They have the power to conduct their own elections, to provide for their public health and safety, establish their own local governments, and they have the power to ratify amendments to the Constitution. You can see powers denied to both as well. So federalism also has the issue of decentralization and centralization. In other words, decentralization is when you cross from Nevada into Arizona and there's a different gas tax, and now you can play the lottery, and you're subject to different laws. They're not entirely, you're subject to federal laws in both those places, but the state of Nevada and the state of Arizona both have their own systems of government, both have their own systems of law. So that's decentralization. Centralization is the idea that, in both places you would use the same currency. In both places you'd be subject to the same federal regulations. There's also, I just want to briefly talk about how federalism has developed over the years, because over time the federal government has assumed a lot of these, has been able to achieve great power within the states via the Commerce Clause. The Commerce Clause in the Constitution allows the federal government to make laws that regulate any kind of interstate commerce. And today, over time, and we'll see some of these cases as we go forward in the semester, some of these, in many cases, the federal government has been seen to have the ability to regulate any commerce because of this greater national marketplace. Even if there's crops that are grown in one state and stay in that state and they're never shipped out of state and never sold out of state, the government still has the ability to regulate that commerce because it affects if all that commerce is still part of the national marketplace. So there's really no such thing as intrastate commerce anymore. All commerce is seen to be interstate commerce, which is why the federal government is seen to have the ability to regulate any and all commerce, no matter where it occurs in the country. They also have expanded federal powers using another clause from the Constitution. It's often called the Elastic Clause or the Necessary and Proper Clause. And in the Constitution, Congress is granted the power to enact any laws that are necessary and proper for it to conduct the business for the welfare of the American people. And using the Elastic Clause and the Commerce Clause, the federal government has really extended its authority into where it is today, where there's pretty much very little day-to-day life in America that's not affected by the federal government. And then in addition to the Elastic Clause and the Commerce Clause, the way the federal government has expanded its powers, especially in recent decades, is by the use or withholding of federal money. There's a good example in the late 70s when, it was actually in the early 80s when the federal government was trying to encourage 21-year-old drinking age for all the states. It threatened to withhold highway funds from the state of South Dakota unless South Dakota raised its drinking age to 21. And that was adjudicated in the Supreme Court and was said that, yes, the federal government does have the authority to. It's not exactly blackmail, but it's similar to blackmail. They were going to withhold federal funds unless the drinking age was raised. And so that, in addition to the Commerce Clause and Elastic Clause, the ability to withhold necessary funding is also a way that the federal government basically can extend its authority over the states in some cases. Okay, so I hope that's a good overview of both balance of powers between the branches of government and also the issues between state and federal government. These issues will be coming up over and over again over the course of the semester, so I wanted to lay it out so you have a decent understanding of how the states and the federal government are going to get along during this early period, and then how that's going to change going forward.